Appeals Division 1 is now in session.
Be seated. Good morning. Now is the time set for oral argument in cause number 1 CACV 150107, Rachel A. Turley et al. Versus Leo R. Beus et al. For your information, for everyone's information, these proceedings are being both audio and video recorded, so barring any unforeseen problems with the technology, you can critique yourselves on YouTube in a couple of weeks. Counsel, each side will, as is the norm, will be entitled to 20 minutes. We would ask that you respect that time. The timer located on the podium will let you know how much time you have left. An appellant, if you wish to reserve any of your time for rebuttal, please let us know. We will try not to take up all of your time and leave that to you. However, ultimately, your reservation of rebuttal time is up to you. We've reviewed the briefs, conferenced the case, so we are well aware of the facts and issues attendant to this argument. We say that so that you can figure out, based on our knowledge of the briefs, what's going to serve your best purpose in argument today. So use your time wisely. And counsel, when you come to the podium, I would ask that you state your name and who you represent. With that, the appellant may begin.
Your Honors, Counsel, may it please the Court. My name is Keith Hendricks. I represent appellants Will and Nicole Carden. They, along with several of their third-party investors that they brought in who've invested in the assets that are ultimately in dispute in this matter, are here with us in court. With me at counsel table is David Rosenbaum of the law firm Osborne Maladon. He represents appellants Todd Nelson and Leo Beus. Mr. Beus is also in the courtroom with us here today. Because of time limitations, I'm going to address the issues raised in the appellant's written briefs. Mr. Rosenbaum and I will divide up any time on rebuttal as we seem fit at that point, and we would like to reserve, if possible, 5 minutes. But most importantly, we want to answer your questions, and that's what we're here to do today.
And whatever your calculation is in that regard, you realize you do have 20 minutes between you?
Correct.
Okay.
And we have discussed that, and that is the allocation that we've agreed upon.
Thank you.
Because of the time limits, but without waiving any of the issues in the briefs, I'd like to focus first on what we are asking for in relief in this matter, and then what we think are some of the most important issues. I'm not going to be able to get to all of the issues, and I'm not waiving any, but I will try to focus on what we think is most important. As described in the briefs, prior to filing this lawsuit, there was an active ADR procedure, and I use that term as opposed to arbitration very deliberately. This was an ADR procedure that had been agreed to and adopted by the parties.
I find that a very interesting statement. What parties agreed to this, and how did they evidence that they agreed to the ADR process?
The corporate, Judge Howard, the corporate entities agreed to it by the virtue that all of the corporate officers, everybody with signing authority for those corporate entities, and by that I mean Beus, Sorte, Rio Claro, the corporate entities that owned the assets, they all signed the management agreement.
So that then limits them to Patrick Carden and Leo Beus. And Wilford Carden.
The three managers of the corporate entities were Patrick Carden, Wilford Carden, and Will Carden, my client.
So they bind everybody else to the ADR procedure then?
Well, they bind all of the corporate entities that own all of the assets. And so the assets that are being divided up are owned solely by the corporate entities. The plaintiffs have no ownership interest in the assets. The corporations or the corporate entities own the assets.
The plaintiffs are the beneficiaries of the trust that own the assets, correct?
No, with all due respect, the trusts own the entities own the assets. They conflate the two, but that's a very important distinction, that the corporate entities and the signatories necessary to bind the corporate entities is simply the three managers. As to the owners of the entities themselves, just like the shareholders or whatevers, they are the trusts, but that's one level removed. And so a very important level. But it still doesn't answer your question, which is how do we bind everybody? That's only half of it. The corporate entities were signed by the execution of the management agreement. Leo Beus's affidavit said that all of the directors, all 5 of the directors, signed the management agreement, and that therefore they were bound, the corporate entities were bound. That was the parties' agreement.
Counsel, I've got the signature pages here in front of me, the only ones we could find in the entire record. I've got 2 signatures wherever those signatures were needed, and nobody else's. Now, and the reason I say that is because you said that Will Carden had signed this.
Yes.
I see Wilford's, and I see Patrick's. I don't see Will's signature on any of the pages.
And I was not involved at the time, and I've understood that. I've gone through it. However, if you look at paragraph 57 of Leo Beus's declaration, he expressly says all signatures from the 5 directors, Will, Wilford, Patrick, Todd, and Leo, were obtained.
So I'm not trying to be the least bit humorous when I say this. The legal principle we're applying here is that if someone says 5 people signed off on something, but you don't have a document to show that they actually did it, all 5 people are still bound?
Well, the legal question for the court and the trial court, and this will go to another issue, and that is whether or not there should have been an evidentiary hearing. But the legal question for the court is, number one, was there a party? There was no dispute at the trial court level or in the appellate briefs here that the 3 principals, including Will, Wilford, and Patrick, signed the management agreement.
But even that's not sufficient under the language of the agreement, is it?
Well, the agreement says that it becomes effective once the 5 directors sign, and Leo Beus's declaration and the parties' then participation over a 5-month period without dispute evidence that there was an execution. This execution of the agreement was never at dispute prior to the time.
It's in question now.
And that comes to what I really think is one of the fundamental issues that you have before you. Under the Breakmasters case that this court issued, the court cited to 7 cases around, and they said if there is a material question as to the existence or terms of an ADR agreement, then the trial court must hold a evidentiary hearing to determine the existence or the terms. This court, quite frankly, is not in a position to rule on those 2 issues. That should have been the trial court's decision, and it should have happened in an evidentiary hearing. Even the case that they cite, the Austin versus Austin case, I found it very interesting, where they found that there was not an execution. That was after a 2-day evidentiary hearing on the existence and terms of any ADR procedure. And that will be what I wanted to ask you, the primary relief that we are going to ask you for. We think that the evidence is, the undisputed evidence is sufficient to find a binding ADR procedure and that the parties are bound to it. At the very least, in the alternative, this case should be reversed and remanded with instructions for the court to follow the directions in the Breakmaster case to hold an evidentiary hearing to determine the existence and terms of any ADR procedure.
Okay, before you go any further, you're saying that it is a binding agreement and that the binding agreement has a binding arbitration provision, right?
The binding agreement has binding ADR procedures in it, including, among other procedures, arbitration. But it is not solely arbitration.
Okay. Tell us what you perceive to be the parties being bound to in regard to arbitration pursuant to the agreement.
And we're getting right back to Judge Howe's initial question. I went through the first half that the corporate entities by virtue of their authorized agents. Now, as to the plaintiffs, we will concede that there is no signature on the management agreement. However, Judge Cooper expressly found that there were genuine issues sufficient for a fact finder to find that they accepted and were bound by the management agreement.
And who are we speaking of?
All of the plaintiffs, now Patrick, one of the 6, there's 7 siblings besides Will. Patrick signed, he's one of the siblings, and he specifically signed and specifically took a seat. I think it's very important that you put this in context. And to put it in context, you have to understand the involvement of the apostles from the Church of Jesus Christ in Latter-day Saints.
As far as they're concerned, they didn't want anything to do with this.
With all due respect, Your Honor, I do not believe that, and I fundamentally disagree with that. There were 5 express instances where the apostles continued to provide advice and guidance post-creation of the board, and that became a very fundamental fact. The evidence in Mr. Beus's...
What became a fundamental fact?
That the apostles' continued involvement with the parties after December of 2013.
So we are not to take at face value the assertion of the church leaders, the apostles, and I mean nothing by that. I want to be very fair and appropriate in the way we address those folks. I have tremendous respect for them. The apostles, as they participated in this, they weren't being honest with us when they said that it was not until they got the letter that they realized they were being expected to be available as an appellate body.
I think that you cannot pick and choose the statements that they did make, because there is a full and complete record. I will say, they did not say we have jurisdiction. That word jurisdiction very much troubled them. They said in that letter and in numerous other letters that they would continue to provide guidance to the people who came to them. And they did provide specific and explicit guidance, but they viewed it in the term of spiritual healing. And that goes to the context of this dispute. This is at its core, is a family disentanglement. That's the word the plaintiffs, through their counsel prior to litigation, referred to it. If you look at Mr. Beus's affidavit, and I would really encourage you to look at particularly paragraph 127. 127 is the summary of the written procedures provided by counsel, the appellant's counsel, Mr. Bob Miller, to Mr. Beus, where he argues on behalf of the 7 siblings for relief in the arbitration procedure. They had legal counsel. He made arguments on their behalf. He presented evidence and oral argument to them, making arguments for the 7 siblings as to the division of property. And in there, they expressly and repeatedly said that this was needed to avoid the trauma of the family disentanglement. And the whole context here, and the reason why this is a very odd situation, and you had the spiritual guidance, is that the implications in the Mormon faith as to the fundamental, if I could say, preeminent role of the family and the eternal nature of a family. A fundamental Mormon doctrine is the importance of families.
Also, we understand that. We really do. The question I have for you is, we are being asked to determine whether or not Judge Cooper's determination to deny the motion to compel arbitration was correct.
Yes.
The agreement has 2 provisions. It has 1.1b, which is the arbitration provision you're wishing to impose, right, or have it be imposed. You with me?
I am with you.
Okay. It also has 1.9. You're saying that that all the parties were bound to this provision. It has 2 arbitration provisions. One says you got to arbitrate. One says that following arbitration you have the right to appeal to the church elders, to the church leaders. All right. In fact, isn't that the totality of the arbitration provision?
Well,
and how can you read those separately if that's what you're suggesting?
No. First place, I think you need the whereas clauses, because the whereas clauses very clearly establish the party's intent. And there's one part that I think, with all due respect to you, that you're missing, and that is the oversight management of the operations. These investments are tenant in common interests in investor-created entities that Will Carden put together.
But I want to know about the arbitration provision.
Okay.
Does it include 1.1 and 1.9?
There is
or is it just 1.1? And the bargained for provision regarding the availability of an appeal process is just gone in the wind.
Well, no, it says that the parties have the right to, quote, make an appeal. Without a capital, it says to make an appeal to the elders. And then it says very specifically, and this was the bargain for position, that the elders may not take the appeal. And they had no obligation. And everybody understood that even if they didn't. And that was the example.
So that doesn't seem like a very worthwhile right of appeal.
Okay. That gets back to the guidance that was involved. There was 5 instances where there was post-creation of the board involvement of the appel. They went to the elders. One, when Wilford wanted his house in his own name without any deduction to will. They went to the apostles, and the apostles said, we think this is not an appellate jurisdiction, but this is guidance. Do not charge it, and they complied with that.
Are you saying that they said that they understood their position under the management agreement and declined jurisdiction?
No, in that they made, quote, an appeal to the apostles. This is where you're putting a legal process into the spiritual guidance for families, and that's the problem we have.
We're not the ones who did it. The people that we're dealing with did that.
If I could point out the point when Wilford was sanctioned, and he did make a formal appeal, and they said very specifically, we're not going to decide those kinds of issues. We're not going to get to, and they said specifically, the board should stay in place. Then they went back to the apostles and said, get rid of Leo and Todd Nelson. And the apostles said, no, we reaffirmed the board. And then they went back a third time, knowing twice that the apostles have told them, we are not going to get involved in the daily management. We will give you our thoughts as we have done with Wilford's case, but we are not going to decide that. They continued with the arbitration process, knowing that that was the facts of the case, that the apostles were not going to sit as your honors would, taking jurisdiction. And they continued with the arbitration, and that one is the formal arbitration after they had notice of that, because that's 109D and C.
And believe me, I'm not trying to be smart. I'm just trying to figure things out. When you say we, who are we?
The plaintiffs together.
You're talking about the 7 siblings.
The 7 siblings created a board of their own. They had a representative on this board. Mr. Beus participated with the Carden family board, which is the 7 siblings. And then the 7 siblings, if you look at paragraph 127, made arguments to the board in an arbitration proceeding after the initial appeal to the apostles, and continued with the arbitration process.
And what evidence is there in the record that the 7 siblings agreed to the ADR process in the management agreement?
Well, their participation, and again, I would encourage you to review Mr. Beus's paragraph 127, Your Honor.
And how is their participation evidence?
They specifically made an argument. They said, we want the title of the property in our name.
Who's that? I mean, you're speaking about the 7 siblings. But what I'm wanting to know is what evidence is there that they agreed to be bound by the by the ADR provision.
Paragraph 124 of Mr. Beus's declaration, citing written proposals that was submitted to the board by Bob Miller. And in here it says, the board has authority to arbitrate disentanglement. Wilford, Phyllis, and 7 siblings seek to credit Will, WRC, proportionally for the value of the residential properties transferred to Wilford, Phyllis, and the 7 siblings. They're asking in this arbitration that the 7 siblings get property transferred to them, and they want to give Will credit for it. Then they specifically say, Wilford, Phyllis, and the 7 siblings seek proportional credit for the residential properties transferred to Will. They're asking in arbitration that they get money. That was the claim that they asserted on their behalf after months of participation. They asked that they be given property. They said the board has the authority to arbitrate it, and they asked that they be given money.
So the evidence of that then is Mr. Beus's affidavit.
And the exhibits to it. And so you have his affidavit describing it, and then all of the exhibits to it that came from, and he describes their participation over months, which gets back to the fundamental issue that Judge Cooper did find. There is facts from which a trier of fact can conclude that they agreed to and accepted the decisions of the management agreement and of the board. And ratification is as effective as a signature. And therefore, at 2 minutes left, I'd like to reserve the remainder of my time.
Counsel, I had a question.
Yes.
I didn't see in the briefs, or at least in your brief, that the appellants requested an evidentiary hearing. Am I missing something? Was there a request that Judge Cooper hold an evidentiary hearing?
There was an argument made in the motion, and the motion filed in early part of December said you cannot make this decision without a evidentiary hearing. There was several times the Breakmaster case was cited to the court, and so yes, in the record that became the ultimate, there was multiple requests or arguments made that these decisions cannot be made without an evidentiary hearing.
And that's in your client's response to in their motion to compel arbitration?
I'm not sure that there was a request, an evidentiary hearing argument. The Breakmaster's case was cited, but I don't know expressly it's made. In the motion for reconsideration, it was clearly made.
Okay. So in the motion for reconsideration,
yes,
you requested evidentiary hearing.
An argument was made that you couldn't make these findings without an evidentiary hearing. I didn't write it. If that, I see that as...
I'm not saying...
So, okay. Thank you, Your Honor.
Counsel, are you going to be the only one arguing on your...
I am, Your Honor.
Okay.
May it please the Court, Alex Grimsley from Bryan Cave, on behalf of the plaintiff appellees. Let me start with the big picture. What's the lawsuit really about? The real question that our lawsuit raises is whether the defendants, fiduciaries under certain trusts, can immunize themselves from liability for violating the terms of the trust by delegating their duties to a board that they appoint themselves to be upon. And that's the big picture question. In the trial court, defendants said, well, we get to decide whether that arrangement is lawful because we appointed ourselves to decide it. Okay. On this appeal, they've pulled back somewhat, and they're really now only seeking to compel certain of the tort claims.
Counsel, what's the inherent authority of the five-member board in the first place? I mean, we can talk in terms of five-member boards. Mm-hmm. It's a board of what? I mean, typically what we look at is a holding company. We look at an overseeing corporation, something like that. And so you can go to that to look at the rules of how that's run to know what they have the authority to do in regard to subordinate assets. Is this making sense to you?
Absolutely.
And I don't mean to disparage you at all. I'm just not sure I'm clear.
I
Explain to me, if you will, what this five-member board really had any inherent authority to do.
From our view, they had none. It's our view the agreement was attempting to create a supra board, if you will, to govern three entities without creating the holding company. Right? So it was essentially...
It also, as I understand it, is attempting to control those companies through an unexecuted management agreement where the businesses themselves have not allowed themselves to be subordinated, if you understand what I'm saying. Is that a fair statement?
That's a fair statement. No holding company was created for the three entities that are the parties, the defined term parties to the management agreement.
Or the trusts?
Or the trust. And the management agreement says that the corporate documents of those three entities will have to be modified. And there's no evidence that ever happened.
Well,
for instance...
Can't we be clear that it never happened?
It never happened.
Thank you.
I mean, if you have an LLC, for instance, right, they say, well, the three managers signed this agreement. Right, but the LLC agreement requires more for the appointment of a new manager, which is essentially what they attempted to do here, was to create a board that would be a new manager for that LLC, create a new board to oversee the operations of the incorporated entity.
So there really wasn't a legal transfer of authority to speak on behalf of those entities. There was just simply an assumption of authority to act on those.
That's our belief.
Go ahead.
Okay. What I wanted to point out was in footnote 202 of their opening brief. The defendants actually concede they're not even appealing the trial court's order with respect to certain counts of our complaint. That's count 1, which seeks a declaration regarding the validity of the trust. Count 4, which is the important one here, because that seeks a declaration as to the validity and enforceability of the management agreement. Right? They say, we're no longer saying that that has to be arbitrated. Right? And the other claims are counts 7, 11, 12, 14, 15, 16. Some of those are tort claims. Some of those ask the trial court, for instance, to remove certain defendants from their fiduciary positions with various trusts for having wrongfully delegated their authority away. So we have this concession in footnote 202. And by conceding that the validity of the management agreement is an issue that the trial court's going to decide, I mean, even if you had a board that could serve as an arbitrator, that's not subject to this process. All the claims, that's a concession of all the claims, because the issue underlying all the other claims is whether this management agreement was a valid transfer of power.
Well, let me go to that. Technically, am I correct that really what Judge Cooper, the issue before Judge Cooper was, is this, can I order arbitration?
Correct.
And she basically found that the arbitration agreements are not enforced. Arbitration agreement is not enforceable for a number of reasons. And we've sort of gone through this a little bit, some of the reasons why. If we were to hold, but she never said the management agreement was not enforceable. But if the arbitration agreement is not enforceable either because of unconscionability or because of lack of execution, isn't the management agreement also non-enforceable?
I think it may depend on the reason. There may be an overlap. For instance, if the first of all, understand we dispute that there's actually an arbitration agreement within the management agreement, so don't take what I'm about to say as a concession on that point. But if the separate supposed arbitration agreement within the management agreement is not valid because the management agreement required at least the 5 signatures of the directors, right?
Under its own terms.
Under its own terms. That would in turn also impact the merits, but that's not a reason not to make that conclusion. If it's correct as a matter of law, it would impact the merits.
The merits of whether the management agreement itself was valid.
Correct.
Or enforceable.
Correct.
But that's not the issue before us. I'm sorry.
Right.
That's not the issue before us.
Correct.
Okay.
There is a motion pending in the trial court on that issue.
Counsel, let me ask you a question I don't think I got an answer on before. There are 2 provisions addressing arbitration in the agreement, and I'm trying to follow off what Judge Kessler just said. One of them addresses the requirement of arbitration, arbitrating back to the self-same group, and this is what Judge Cooper addressed. It's unconscionable to say 5 people decide, and if they don't do it the way you like it, ask them a second time, is basically what took place, correct?
Correct.
All right. So we recognize that's there. But can that be read separately? And from my review of the record, I've got a real problem with people that I don't mean people, with the understandings of a group who said we can go with this if we have the right to appeal outside of the same people that made the decision in the first place. And that was agreed to, was it not?
Depending on the scope of what the issues are, I think there are a couple of the plaintiffs did sign on to the management agreement.
Well, in fact, didn't the parties say, once they found out that the elders were saying that they could not or would not participate in the appeal process, they said, then we don't feel we're bound by the balance of it?
Correct. That was a provision that was added, the evidence before the trial court. And let me just backtrack very quickly, because in the context of deciding the motion to compel, the trial court's empowered to make incidental factual findings. And the court's held, and I think the court has already alluded to this indirectly, but the court's held in numerous cases that if you don't request an evidentiary hearing, you waive that argument on appeal. Okay? And this is an appeal from the underlying orders, not from a denial of a motion for reconsideration, which is raising the issue too late, with all due respect.
In any event, motion for reconsideration can't raise new issues
Correct.
that weren't raised in the original pleadings.
Correct. So I think the whole issue of sending it back. So the trial court had the authority to make the fact findings. Trial court clearly held that the two elders of the church wanted nothing to do with a legal responsibility under this agreement to hear appeals.
Or just on this issue?
Generally.
Thank you.
Okay. And the evidence was undisputed that the provision allowing an appeal to those two elders was specifically requested by this firm's two clients who actually signed the agreement. It was a condition to their agreement that they always have the right to ask the elders to hear a legally binding appeal, right? Not to go and seek their guidance. Of course, they're always going to have the ability to seek the spiritual guidance from a church leader, right?
So we know today that based upon, as I understand and as you're telling me, the elders' position that they were not going to participate in the judicial aspect of the appeal, that basically got lifted off or nullified. It was nullified within the agreement. Is that correct?
Well, they actually asked that the language be, the elders asked that it be removed because they could not accept the responsibility.
So then what the people that would be bound by the, I'm trying to figure out how to characterize things.
Well, the conditions to their agreement.
They have the obligation to arbitrate, but not the opportunity to appeal, which was a part of this thing from the get-go. Is that not correct?
It was part of the agreement from the get-go. I mean, it's part of the, it was argued as mutual mistake or misrepresentation. You could also consider it a failure of consideration. Right? This is part of the bargain for agreeing to have issues heard by this board of 5. Part of the bargain was that we will always have the right to ask these other two people who are removed from that process to hear an appeal.
Yeah, the argument is being made that what they bargained for was the right to ask, not the right to have the elders decide. And it seems to be a very weak right of appeal.
It's an appeal much as you might have to the Arizona Supreme Court or the U.S. Supreme Court, where they have the discretion to take it or not. But declining to hear it, exercising your legal authority to decline to hear an appeal, we submit is fundamentally different from declining any legal authority to do it ever. Right? Two different issues in our view.
It's even stronger than that, isn't it? They're saying we're not involved in this. We never agreed to do this. We never even agreed to consider these things. So take our names off of this.
Right.
That would
remove that provision.
That's different than
please.
saying we exercise our discretion not to hear the appeal.
Right. And that is as found by the trial court, that they want nothing to do with it. And those findings that the trial court made are entitled to deference unless clearly erroneous.
It appears that what the parties, and I'll use that term vaguely for the moment, that what the parties wanted in the appeal provision, they never could have gotten because the elders didn't want to do that. And they expressly said, we're not doing that.
Absolutely.
So that ultimately, to put some color on the picture here, the assertion is that Patrick conceded to the arbitration, but was denied the appeal provision that he and Wilford, and I don't mean to be too familiar, but that's the way we distinguish here, that Patrick is required to arbitrate, but now has no appeal rights, even though he and Wilford demanded that the appeal rights be included within the agreement before they would participate?
That's correct.
A question I've had about this is, it can be argued from the record that Patrick consented to be bound by the 80-hour provision or the arbitration provision, however you want to characterize it. But is that enough to, assuming that he signed it and intended to be bound, does that bind him if the other necessary parties haven't signed it and aren't bound?
I think the court started with this issue that the only copies of the management agreement in the record only bear 2 signatures. By its term,
we can confirm that for you, counsel.
By its terms, it requires at least the first 5. So defendants never actually got off of, home plate with a bunt even, because they never put in a fully executed copy of the agreement.
But what do you do with the affidavit?
The affidavit says after it was done, and of course that is not undisputed evidence. I don't know one way or the other whether it was executed, but they bore the burden, and that affidavit came in with their reply brief.
Okay.
Okay. And if they were going to try to prove the existence of an agreement to support a motion to compel, right, they're obligated to put that in with their opening brief with the evidence, right? They can't wait until the reply brief to
But
do so.
they didn't attach to the reply brief copies of the fully executed agreements.
No, they did not.
Counsel, I want to ask a question I don't want to go too deeply into, but can we assume for purposes of the record that Mr. Beus was not representing the members of the Carden family, the 7 siblings, as they have in alliteration become known? He was not representing them as counsel, so he had no right to speak for them as counsel at the time that he says they signed off on this?
That's correct, and I believe one of his declarations, there's 2 of his declarations, one of his declarations actually says, I informed everyone I could not act as counsel to either side.
Correct.
Right, but I would assist with drafting.
And what I'm saying is
the
he was
document.
not communicating information by counsel from the client in regard to their position.
Correct.
Okay.
And in that regard, too, we heard some argument about the arbitration. I'm going to put little air quotes around that because we just think it was a hearing where Patrick wrote certain things on his slides. His testimony was he was parroting what Mr. Beus had told him so that there'd be, this is the sort of premise on which we're here, is I was told these things. That was his testimony. Trial judge can believe it or not believe it. But the point is, they keep saying that all of the other siblings participated in that proceeding. None of them attended that proceeding. None of them were represented. We represent all of them now. At that time, and this is in the record, we only represented Patrick, this law firm.
Well, it certainly seems that once you get outside of the Big Five, the management group, whatever we're calling it, the 5 folks, and believe me, I can name them each and every one now. But once we get outside of that group, identification becomes pretty vague. And as I said, there's an assumption, I think, that 7 siblings agreed. There's an assumption that 7 siblings agreed to sign off on it, however you want to say it.
Right.
Fair statement or not a fair statement?
Mr. Beus says he met with them. I wasn't there. He says he met with them. He explained the agreement to them, but he never actually says they all said they agreed with it, right? They all say we weren't even asked whether we were going to agree to it. So I think to the extent someone acted in good faith, right? You can still breach your fiduciary duty without having bad motive. Okay? To the extent any of the 5 were trying to decide these issues and they were trying to do so in good faith, I think in that instance they were operating under an assumption that everyone had agreed, when in fact everyone had not agreed.
When in fact, if you look at the signature pages, not much had been done to determine whether or not they agreed.
Right. Right. They hadn't even been, I mean, the testimony undisputed, they hadn't even been asked to sign. Okay.
What else you got for us?
That's really all. I did want to touch briefly. There was some supplemental authority that was submitted in context of the unconscionability analysis.
For the record, we received a notice yesterday that a supplemental authority had been filed. I've not reviewed it. I don't know that any of us have reviewed it at this point. Do you want to take a position on that?
Well, no, I think it's very late in the day to be submitting new authority.
It was way late in the day for us to get ready for this hearing and review it.
But just very briefly, those cases address a different issue. Both of those cases involve attempts to vacate an arbitration award that's already been entered. Okay? And the standard there is very different. Second, both cases arise in the context of collective bargaining agreements. And so there's the overlay of the Labor Relations Management Act. And just very briefly, I mean, the Eighth Circuit opinion that was cited says vacatur of an arbitration award is appropriate only when the decision does not draw its essence from the collective bargaining agreement. And the Second Circuit echoed that same idea, that we may not disturb an award so long as he, referring to the arbitrator, acted within the bounds of his bargained for authority. In other words, the issue in those cases was, did this arbitrator, who, by the way, was not a party, right? In one of the cases, he was the NFL commissioner, okay, but the league is not a party to the collective bargaining agreement between the players' union and the teams. The teams belong to the league as a trade association, essentially. So it's not actually a party being an arbitrator. But anyway, the overlay of those cases with federal law, not state law, with the limited review simply makes them inapposite. And that's all I have.
Thank you, Counsel. Counsel, you don't have your 5 minutes, but give us your best shot.
On April 1st, the trial court ruling, this is the literal ruling, as to all plaintiffs, there are issues of fact as to whether, by their conduct, they ratified and accepted the management agreement and or the board and or individual decisions by the board. She found that there was evidence in the record of whether they accepted it. Under the Breakmaster's case, when the existence or terms of an ADR agreement are in dispute, then the case says the trial court shall hold a hearing.
What happens if the court says, I don't care if they agree to it?
I don't.
What if the court says, okay, they may have agreed to it, but it's unconscionable?
As to the unconscionable argument, those are the ones that are briefed. The NFL, as to whether they can rule on their own, if the parties agree to it under contract, that's what ADR is, a contractual way to resolve it. And if that's the way you want to resolve it, by having Todd Nelson, a completely independent, by Leo Beus, the longtime attorney from the parties.
Yes. We've had cases where it's undisputed the parties have agreed to an arbitration provision. And yet the court has invalidated it because they found that it was unconscionable.
That would be procedural or substantive unconscionability arguments that are not present in this case.
But I understand that. I understand your argument is that it was not unconscionable. But if the court finds that it's unconscionable, it doesn't have to be, they don't need an evidentiary hearing about whether the parties agreed. Would you agree to that?
Yes, I agree with that.
Okay.
Counsel, thank you.
Thank you, Your Honor.
We had, as I hope you understand, some substantial interest in the facts of this case. We really appreciate your attention to our questions and our concerns. We appreciate the time you obviously spent in preparing for this, and thank you for your comments to us today. Oral argument can make a difference. So thank you for that. We're going to take this under advisement at this time, and our decision will issue in due course. Thank you.